Hello, everybody. Welcome on behalf of Kri Foundation and the Visual Arts Gallery of the India Habitat Center. I welcome you all to this fourth session of the webinars, 5 webinars that we had produced on the issue of arts and the law. We've touched many key issues: sexual harassment, drugs, and the use of in the arts. We've looked at copyright and plagiarism. And today we are going to look at something that really came up right away during the COVID period. And this was a hit on livelihoods. It made us look at the largeness of the issues, and we realized that one problem area was that the artists weren't protected by the power of the law, which comes to them through contracts. So when we decided to do this 5-part series on the intersection between art issues and law, we definitely wanted to focus on contracts. Don't think that the contract is a simple document. It is actually, it has a formula to it. And to tell us about it, we have amazing speakers who I will introduce you to in just a moment. But also, I want you to realize that it is a mindset that gives value to your own cultural wealth, which is your artistic wealth. So being aware of contracts, pushing for contracts, it'll actually need a breakthrough in the mindsets um, of the constituency of arts and artists to be able to think value to your work, which for too long has been cited in terms of manoranjan, anand, rasa swadan, words like this, hridayata. What value can you give such terms? But you have to look at protecting ourselves. All of us have to look at protecting ourselves. Anybody who brings any wealth into the cultural domain needs to look at protecting ourselves from situations like we are facing now in the COVID pandemic times, and from any other possibility of having our rights abused. So let me, with these words, tell you that the formal title of today's program is What Artists Should Know About Contracts, Force Majeure, and Acts of God. I'm sure you're going to laugh and say, what is this French business going on? But force majeure and acts of God are terms that we are hearing a lot these days. We hear it not just in the legal domain, but we are hearing it increasingly in the economic sector as well. And acts of God has been cited by the government of India to sort of get out of some of their commitments. Before I introduce the artists, before I introduce the speakers for today's webinar, may I request all of you to please turn off your mics. It's absolutely essential that you mute your mics, please. I still see some that are on. I request you to mute your mic. Thank you. It is helpful even if you turn your cameras off, because in case you move, it becomes distracting, but that's okay. I won't insist on that. And with these words, let me quickly welcome our 2 speakers today. Every session of Arts and the Law has had a legal expert, and our legal expert is an absolutely brilliant lawyer, advocate of the Supreme Court, Sujit Ghosh. Not only is he a persuasive speaker, but he is absolutely a master on issues of contracts and related topics. I don't think I'm even equipped to talk about how related and which related topics, but I have heard him speak in law fields. I've heard him speak outside law gatherings, and I think he speaks making things quite easy. And that is why it's been a privilege for us to be able to have him lead this webinar from the legal perspective. To lead this webinar as the discussant from the artistic point of view is somebody who really needs no introduction to the house that I see forming here. And that is Sanjoy Roy. Sanjoy is an amazing person who traverses the vertical associations of the arts. He's working at the grassroots levels, he's working at the policy levels, he works with FICCI's Committee on the Arts, and so he traverses many stakeholder domains in the arts. His perspective with international works as well, because as you know, he not just founded the Jaipur Literature Festival, but has led many international festivals and artists to international festivals. I remember a time when Edinburgh was incomplete without Sanjoy. So, with that, these words, I would like to just mention finally that your questions can begin even as we start the program, as soon as the first slide opens, but you have to type them out in the chat section. We will take it on towards the end. From now on, we will have for the next 30 minutes, Mr. Sujit Ghosh speaking, and then for about 20 minutes, Sanjoy Roy speaking, and then we open it to answer your questions. We have enough time since our session lasts till 8:15. So Sanjoy, welcome. Sujit, welcome. Thank you so much for doing this for us. With these words,
Thank you.
Sujit.
Thank you, Dr. Sethi, for having invited me to speak to all of you. And it's great to meet some of you that, most of you that I've never met and I have only heard about. And Sanjoy, you're doing a marvelous job on the Jaipur Lit Fest, and I have always aspired to be there, but I guess we'll have to wait until this pandemic gets over. I'm a lawyer, so I'm not an artist. But tell you what, I used to have some artistic flair at some point in time in my life. I used to be the cultural secretary of my university. I did some bit of playing of some instrumental stuff back then when I was younger. And my daughter has been, pupil to Birju Maharaj. So there has been a bit of a art culture in our family in some sense. But well, that's not enough for me to be part of this gathering. But I guess I'm being invited because of my legal prowess rather than artistic flair. Be that as it may be, the topic that I have been given is a very sensitive one. And I do appreciate the fact that all of you who come from the world of art love your art as much and so much that the mundane things like contracts, payment schedules, disputes are a botheration. You rather get along doing your stuff, and you would wish that the world was as fair as it should be. But unfortunately, the world is not as fair. Let's face it. And the message that I want to give in today's discourse is that any form of professional skill, I'm a lawyer, somebody's a doctor, you're an artist of any kind. If you want to monetize your skill sets, there is a commercial angle that comes in. Until you wish to monetize, love and fresh air can carry you through. There's no need for contract, nothing of that sort. But the moment you wish to monetize from the pedestal of art on the various, spiritual aspect and the subtleties of life, it kind of gets into the realm of commercial life. And once you brace the commercial life, then it is like a cutthroat world. You have to brace for what the commercial world wants you to go through, and therefore there is no looking back. So whenever we speak about contracts and whenever we speak about disputes, whenever we speak about force majeure, all of that and more is relevant only when you are seeking to monetize. So keep this very fundamental thing in mind. And I have a short presentation for you all. I will not make it technical. I'll go very simple so that you're able to appreciate the nuances in a very simplistic manner. So allow me to project my presentation that I have, which will come on your screen in a moment. Right. So the objective of what we're going to drive in our conversation today is that why do we need contracts? What are the best practices of contracts that we must follow? And how do we deal with, which is the second part, how do we deal with disruptions of the kind that we have seen in the last 6-7 months or maybe 9 months, which is COVID kind of situation. And today it is COVID, tomorrow it could be something else, God forbid. So therefore, two fundamental elements of this discussion. First is why a contract, what are the best practices? And second is what if they have another COVID-like a situation, or for that matter, how do you deal with the COVID-like situation currently? And then third is more like a suggestion of how do you take your acts, make your acts for the coming in periods in terms of the road ahead and your plan and strategy. So basically, like I said, and this I repeat again, that monetization of skill sets comes with a price. You have to brace that. You cannot escape that. And the price is essentially of two kinds. When I say price, I'm not talking about money. Price is the cost of being in that business of monetization. Is of two kinds. One is the protection of your right, and the second is the enforcement of your right. And what kind of rights are we talking about here? We are essentially talking about your creative rights, your intellectual property. You may have created music or scratch, or you may have created a dance choreography, or whatever you may do, or a painting, or whatever which you seek to monetize. That right or that intellectual property needs to be protected, and you will not be able to get that protection unless those rights are codified, which I'll talk about subsequently. So your creative rights are very important. You need to be essentially protecting them. Then the right to be paid for the performance. I mean, it's not love and fresh air that you're doing. There is a compensation attached to that, or a fee attached to that, or whatever you may call it. That right needs to be protected. It should be paid on time. It should be paid as per what has been agreed. It shouldn't happen that after the performance has happened, you only get 70% and say, tough luck. Sorry, it's dead and gone. So what do you do in that situation? So therefore, you have to enforce your right to be paid on time in accordance with what you have agreed with them. Then right to be retained in a performance, assuming that it's a 1 year contract or 1 year relationship that you have entered into any organization, and therefore you've blocked your time, your valuable time. You're not available to any other agency, and therefore during that time, if you're asked and if you're told that sorry, this is getting terminated, or I don't need you for the next performance, then it is likely to lead to financial loss for you, or time and money spent on something, some commitment that you would have made, it's like a loss for you. So therefore the right to be retained for the job that you have been called upon, right to perform, and therefore that needs to be protected as well. Then the right to deal with emergent eventualities, like COVID is one such example. There's an emergent eventualities, and we'll talk about a little more down the chain, but that has to be also looked upon. How do you deal with those emergent eventualities? And lastly, the right to operate in a safe environment and with dignity. Now, I hear and I read, and I could be completely wrong, and pardon my saying that. I keep hearing that there's a lot of exploitation that happens to people who are in this business. And this exploitation could be of many kind. It could be some kind of a quasi or a pseudo slavery, some kind of a bonded labor kind of an approach. Sometimes there are sexual harassment kind of insinuation that comes through, various kinds of things that happens, and you will all know better. And I'm not here being judgmental about it, but nevertheless, the right to operate in a safe environment is your fundamental commercial right that you seek to ask, you must ask for. And I give a simple example. If you have a painter that comes to your house, and the painter is going to paint your house inside, and if something happens to the roof falls down, then the painter will have to be compensated for that. It's called an occupier's liability, in the sense that the house owner who actually called the painter to provide a service must ensure that the environment under which he's going to perform should be safe, and his health should not be under any kind of jeopardy and injury. So therefore that concept is very integral to every kind of service delivery, and therefore in this situation also, the fact that you need to be operating in a safe environment with dignity, and I stress on the word dignity, because at the end of the day, all professionals, we operate because of our skill sets, and therefore we pride what we have, and that pride is more important than the money that we seek to earn. Take that pride away, we are nothing actually, and therefore that dignity is very important. So your right to operate in a safe environment and with dignity is fundamental, and there can be no compromise about that. And therefore, all of these things, all of these rights needs to be codified. And that codification is called a contract. So, I mean, putting it very simply, when there is an offer made by somebody and you consent to that offer, that yes, I shall perform. And when you reduce that consent and the offer and consent into a document, which enforces, which binds the two parties, the promisor and the promisee, the reciprocal promises that the parties have made, that when reduced in a document is called a contract. Okay, and in such contract, which is, and that agreement enforceable in law is a contract. So simply put, any arrangement between two parties to do something and seek compensation for that is a contract. Now contract necessarily does not mean it should be written. Okay, contract could be oral as well. The Indian Contract Act says that it is not necessary that you need to have a written contract. But then you need contracts the moment the arrangement between the two parties becomes sour. Because till the time everything is lovey-dovey and everything is going as per planned, nobody really bothers about contracts. So fat documents of 100 pages are as good as some old book that is lying on the shelf, which is of no use. But the moment the trouble starts brewing in the relationship, that is when you need to contract. And at that point in time, you would wish that if I had a written contract, I would have been able to substantiate my claims or substantiate my rights or substantiate the corresponding obligations that the counterparty had put in a better fashion. So essentially, if you ask me, is there a written contract that is mandatory? The answer is no. You can certainly live with an oral contract, even email, doesn't matter. But if you ask me, is it a best practice? Is it a best practice to only operate in an oral contract? I would say never. You must necessarily have a written document which clearly etches out the roles and responsibilities and the corresponding obligations of both the parties and the rights and liabilities that accrue in that commercial relationship of monetization of the skill sets that we're talking about, such that should such a dispute happen, you can take that piece of paper to the appropriate authority who's going to be an arbitrator for you to say that, hey, my rights have been infringed and therefore I need a protection, I need an enforcement. But if you didn't have a written document, then it gets extremely difficult. Then it is your word against the other person's word. And then there are corroborative evidences and surrounding evidences, and you go on to a spin and spin and spin, and that gets very difficult for you to substantiate. So written contracts acts as an effective tool to show clear evidence of your rights and counterparties' obligations, and therefore it is a best practice that you must have. Codification of the respective promises and attendant rights are therefore very, very important. And enforcement of rights under written contracts requires that the contract should be registered on payment of an appropriate stamp duty. Now, this stamp duty in all of these kind of contracts for services of this kind will be no more than 100 rupees or so. It's not some hefty money that you do. But then keep in mind, whenever you go to a court of law, if, God forbid, you have to get into that arena, your rights under that contract cannot be enforced unless you have paid adequate stamp duty. And therefore, it does not become enforceable unless it is registered. So it is always a good thing to not only have a written document, but also to have paid the stamp duty, which could be no more than 100 rupees. It's a small thing. It's no less than, when you get into a lease, you are so fond about your property. You want to protect the property. You enter into a lease. Would you or would you not put it on a stamp paper? You would, because you are actually concerned about the property. Your intellectual rights or your intellectual skills is as much a property, and you need to therefore curate it in the same fashion that you would have actually curated a tangible property like your house or your villa, whatever else you may have. So I would strongly recommend that not only should you document it in the form of a written contract, but also you must get it stamped to ensure that tomorrow you are not caught on the wrong foot. Now, what are the things that your contract should contain? Now, these are very basic things, and for us, for us, these are very basic things. But for all of you who come from the world of art, it may be quite a trouble. But I tell you, if you cross this trouble, then across the tunnel there is a great amount of light, of liberty, of protection of your rights. So this is a small tunnel that you have to go through at the beginning, and not necessarily it's in continuum. So therefore it's a one-time effort that you have to go through. So what exactly have you been called to perform? That should be very clear. There should be no ambiguity whatsoever insofar as what you are supposed to be performing, the time when you should perform, the place where you must perform, the nature of performance that is to be carried out by you, and all kinds of things. So your role or your responsibility or the services element of what you are going to be, you've been called upon to perform, should be very clearly etched up. So if it's a dance drama, then dance drama. If it is a poetry, whatever it is, that should be very clearly etched out, that you've been called upon to do X, for which there is a consideration that you will seek. So that if there is a question of any deficient supply, please keep in mind, again, related back, You go to a tailor, you ask him to make a shirt, and the fellow does not make the shirt that you want. Will you pay him the full money? The answer is no. You'll say, look, I asked for a full sleeve shirt. You made a half sleeve shirt out of it. Why should I pay you? And that dispute will arise in terms of what exactly was called upon by you or by the performer or by the service provider. Such that such dispute does not happen. There should be clarity in the contract in terms of what you've been called upon to do so. Second, you have agreed to perform based on some representations that the other party has made. I shall make available the hall, or I shall make available the venue, so and so venue, or I shall make sure that the tickets are sold. It is my responsibility. Various representations would have been made, that must be made. If not made, they must make, in terms of what is the counterparty's obligation in respect of the arrangement that has been entered into. So that tomorrow they should not turn back and say, sorry, I can't pay you because ticket sales did not happen, unless your price or your service charges are connected to the sale of tickets. But if it is not, then how does it matter whether the agency sold the tickets or not? It really does not matter. You have to be paid and you have to be paid. So therefore, the reps and warranties that the counterparty makes, or the agency who's organizing it, who is called upon to do that, it must be very clear. They must also make a representation in terms of the health and safety norms, covenants on exploitation of any kind, whether it's sexual harassment or any kind of exploitation. They must make those covenants very clear in terms of what their obligations are, what are they bringing on the table as a commitment before you can accept. I mean, it's a given that they can't have a open-ended sky saying that well, whatever my obligations are, you don't need to worry about. You must know about it. You must, because after having read through that is when you agree. You will obviously not get into a contract which is a complete dark hole. So therefore, the representations, warranties offered by the counterparty should be very, very clearly laid out in that contract. You must also know if there is a how do you if there is any dispute that happens, what should be the resolution matrix, because oftentimes the person who are interacting with may not be the final decision maker. There could be somebody else behind the scene. There could be somebody superior, and therefore if that discussion kind of hits a dead end, you must know what is the escalation matrix. It's very simple. Take it to your normal life. If you call an Airtel consumer, number, and the fellow is not able to answer you, you'll call for an escalation. Maybe some superior officer. Very similar to that. So the person who's actually coordinating may not necessarily be the ultimate decision maker. Some things may need to be escalated, and therefore that escalation matrix should be very clearly provided. If you're able to get that, that is really a good practice to have. Then, what is the consideration that the counterparty may pay you for the performance? Now, when I say consideration, essentially I'm talking about the compensation. And the compensation could be an advance, 50% advance, entire advance, or there must be a payment schedule, whatever it is, whatever you may agree to, that should be clearly brought out. Because if you're not paid on time, then there is a breach of the contract that has happened, and therefore you should have a right to enforce payment on time. So therefore, that should also very clearly come out in terms of what payment and what is the payment schedule. Then what are the protections that you're seeking onto your intellectual property rights? There should be very, very clear statement in the contract who owns the IP of what is going to evolve after your performance. It is possible that in a given show, there could be multiple IPs that are emanating. Well, those are complex situations, and therefore each of the performers will have to come out with some kind of a grid or some kind of a common solution so to do that. But then whatever it is, to the extent that you have actually done your performance, the IP right, unless you give away, and that's very important. It's possible that you may give away also. You may give away and say that the IP vests with the organizer. Fine, that's fine. But at least be clear about what aspect of that is given away and what aspect of the IP will devolve or kind of vest with the organizers. But you must have a clarity. I would always encourage that the artist community should liaise with a good intellectual property lawyer. I'm not an intellectual property lawyer. I'm probably not the best person to give you advice on that. But I do know of the fact that intellectual property rights are very, very critical and very important when it comes to artists, and therefore that needs to be protected. At the end of the day, your skill sets, if copied by somebody else, you lose value. And therefore there is a very, very important need for you to protect that right, which is a very valuable right, because you survive not because you have commoditized the skill set. You survive because your skill set is unique. God has gifted you something, you have trained hard, and therefore you have a right to preserve and protect that, and therefore make no compromise about that particular thing. And the choice of you giving away that IPR to the agency concerned is completely yours. And should you have done that, then fine, you are okay with that. But that's a choice. But wherever you have not chosen to kind of allow somebody else to take over the IPA, you must protect it like a lioness, if I were to use that word. Then what are the other things that the contract should contain? The next point is very important: the remedies if there is a breach. Now, in contract law, there are two kinds of remedies that are available. First is a contract law contemplates specific performance, which means if there is a breach by one party, then the other party can ask the defaulting party to specifically perform their scope of work. If, in other words, if somebody has performed and the other party reneges the contract by not making payment, then there is a specific performance that you can ask from the defaulting party, you make that payment. That's called a specific performance, and therefore that should be there. Second is remedy of restitution. In legal language, we call it restitution, but essentially it's called a damages, which means that the injury that I may have suffered because of your breach, you need to compensate me and put me to the same economic position where I should have been but for your breach. So there is a damages, and this word damages you would have heard umpteen times in your lifetime. So and so has sued for damages. So and so has kind of sued for damages. Those damages are basically compensation for the loss. So specific performance is to ensure that you enforce the contractual rights. Damages are attendant additional thing that you can call for should there be any loss that you may have suffered for the other party having breached the contract and so on and so forth. Now that mechanism of dispute resolution has to be also contemplated in the contract. Now don't get scared that for every dispute you need to go to the court, because today the alternate dispute resolution mechanism that the Indian subcontinent, or India for that matter, holds is a very promising one. You can first layer, it could be mediation. You try to mediate between the defaulter and try to come with an amicable solution. If you fail to achieve mediation, then you go for an arbitration. An arbitration is not a court proceeding stricto sensu. You don't have to go to a lawyer. Of course, you may need a legal assistant, but you don't have to do chakkars of the law offices of a high court or a district court or whatever. It happens in a quite conducive environment. It's more informal in that sense. And should you think that arbitration is going to not kind of succeed or has failed, only then you go to district courts. In your case, it will be the district courts. So the point I'm making is that the dispute resolution mechanism or escalation mechanism for a dispute resolution must also be very clear. If you do not put mediation, arbitration, and then court, then you will have no choice but only to go to court, which could be a painful affair, because we all know in India the justice delivery system takes as long as it takes. It takes forever for a small issue to get resolved, and it doesn't halt there. It kind of goes on and on until it kind of dies. By the time it goes to Supreme Court, you're like 30 years is gone. So direct approach to courts is never a good idea in these kind of situation. Probably a better approach could be try to do a mediation, reconciliation, if not then an arbitration, failing which you go to the courts. So that by the time, I think some of these relationships that the artist community will have with agencies are long term, and nobody would like to carry the defaulting sentiment or the kind of fight for a very long time. Everybody needs the other person, and therefore they are going to be more likely than not amicable in their approach, and therefore a mediation arbitration is best suited. How do you deal with the special circumstances like COVID-19, an act of God, etc.? So this is something that you need to deal with, which I'll talk about in the second part of the presentation. So therefore, to summarize, the key best practice in drafting of contracts, you have it on your slide. It must document the precise understanding of the parties, which is called the consensus addendum. If you've asked for something, that something is what it should be. It should not be an alternative. So if it is a blue ball that has been asked for, it should be blue ball, not a purple ball. That's a very simple way in which we put it, consensus addendum. If you've asked for 30 pounds per hour, then it is 30 pounds per hour. There is nothing like 29.99 pounds. So consensus addendum, which is the matching of mind with respect to what is to be performed and how much is to be sought under what circumstances. Okay. Language must be simple to understand. There is no need to start the contract whereas and therefore and so on and so forth. Those legalese is not needed. The purpose of contract is to not make it esoteric and make it look like one biblical document of the Victorian age. Nothing of that sort. It can be as simple as normal human beings would kind of have a conversation. It should be as simple in that sense. Okay, language should be simple so that it cannot be misinterpreted, because the legal principle is that if you use language which is susceptible to multiple meanings, you have created a hole in the bucket, and there will be leakages. So avoid complicated language, avoid, use simple English which is easy to understand. No need for grand words and jargons from the days of yore, nothing of that sort. But sometimes there are some words which are necessarily legalist, which needs to be there, because those words have a defined meaning in the law of contract. Words like force majeure, it's a legal term which has its own meaning. It probably cannot be misconstrued beyond a point. Okay, so promise, consideration, those are also legal words. So some legal words will get etched into the contract as a necessary concomitant of it being a contract. That is about it. Okay, so avoid legalese unless it is necessary. Seek help of a lawyer. It's like, we all do self medication. We all think that we will get okay, so long as it's a general flu, it's all fine. But the moment it gets into COVID like situation, you need a specialist doctor. So because you're preserving and protecting a very valuable right in terms of your skill set, I would, to err on the side of caution, take help of a lawyer who understands the subject of contract. It is better to pay that price at the beginning rather than to suffer it later. A stitch in time saves nine. That's the adage that I would like to use. Stitch in time saves nine. So it's better to take the consultation today rather than having to suffer tomorrow. And email arrangements, completely, it should be avoided. They are neither here nor there. I mean, it can be easily broken by saying that, oh, I meant so and so through that email. And you may say that, no, but I replied, you were in CC, and you did not raise an objection. You should have. And say, well, it was in CC, it was not marked to me, I was not obliged to respond. So all kinds of emails create more confusion, and it gives room for consternation and room for debate, discussion, which is avoidable. So don't include this email. Fine, you may agree the contours of an arrangement through an email, but soon after that, reduce it into writing in the form of a contract. That is very important. And that in that contract, you should have a very valuable piece of line, says that all prior communication between the parties are rescinded, are revoked, and all of that is to be governed by this piece of paper, which is the ultimate document. Because if you don't say that, it will mean that this contract and the earlier email, they will have to be read together, and it gets to complexities. It's never a good idea. So in summary, short, sweet, sharp document enumerating your contractual arrangement is what is the need of the hour. The sharper and shorter the document is easy to maneuver. There is no need. You're not selling, you're not doing some heavy duty construction of a port, or any kind of complex contract where all of these things will have to be. It's a very simple thing. Keep it simple. Life remains simple. Now we come to COVID, which is the second part of my conversation. Now, I must tell you, I'll give you a history to that. I'm sorry, I'm going to trouble you with some legal history, but it's important. In the good old days, under the English law, we've had situation where artists, actually it started with artists. Artists had to perform at 7 p.m. on a given day in London. Okay, and on that day she fell ill. She was not well, and therefore she could not come to the venue where she was supposed to perform. The agency who had hired the artist filed a suit for specific performance, saying that you need to perform, else pay a compensation or a damages. The artist went to court and said, look, what could I have done? I was sick that evening at 7 o'clock, and here are the doctor reports or whatever to substantiate that I was sick. And time was of essence, because when you call for a show at 7 p.m. and the entire audience is on the floor waiting for the performer to perform, and if it doesn't happen, the audience is not going to come back the next day. This is not a rematch of a IPL or whatever else. You can have a second day final or whatever. Those are exceptional situations. But most performancer time is of essence. And if she couldn't turn up, not because she didn't want to turn up, it's because she couldn't come up. And that inability to come for that performance was because of an event that was not in her control. She had fever. And that's when the English court evolved, that this is a situation where the justice demands that a unconditional contract or an absolute contract of performance should be made conditional to offer relief to deal with such unexpected events which was not even contemplated by the parties. And the fact that the artist actually fell sick on that evening was an unexpected event that neither of the parties could have foreseen. And therefore, she will be allowed to have discharged her commitment, even though she did not come for that day. That was the evolution that happened under the English law. And there are any number of decisions on that, all of that you have. So basically, the English took a stride on creating conditional contracts in case of unconditional closed-ended contracts to allow non-performance in a situation where there was an eventuality that neither party had conceived. Turn around that thing to Indian context, and the answer to that is not as simple as what the English law was. Okay, Indian law. Okay, Indian law talks about a completely different concept. Indian law says, look, the primary guiding factor is going to be the contract. And that is why I'm trying to labor on why contracts are important. Primary guiding line is the contract. If in the contract, parties have specifically listed that if so and so event happens, then the performer, either party, shall be discharged from discharging his obligation, then only then can such a discharge can happen. Put it simply, let us say you have a contract, and I'll not give an artistic example, I'll give a live example. Let us say Indian Oil Corporation, and I'm using a name not because they are in any kind of issue, but just an illustrative name. Indian Oil Corporation was obliged under a contract to supply 100 liters of petrol, and it could not do so because on the way there was a fire that happened, a forest fire or something that it was just not conceived, it was just not possible to foresee. And that fire happened not because of Indian Oil's dereliction, it happened because there was a thunderstorm or some lightning, something happened, and which is called the act of God. It was God's intervention that kind of made the performance of delivery of this 100 liters of petrol impossible. In that situation, if the contract says that should such a lightning happen leading to non-performance, then Indian Oil shall be discharged from the contract. Then the buyer of the fuel or the petrol cannot turn back and say, notwithstanding the fire that may have happened, Indian Oil must necessarily supply again. That is that's called an act of discharge of contractual obligation on account of act of God. So fire, flood, terrorist attack, atomic explosion, all kinds of natural calamities are usually considered to be act of God. And people reduce those natural calamities in a contract to create an escape clause. Now, mind you, this act of God or force majeure, as we call it, force majeure is the general category. Act of God is one of them. Is a double-edged sword. If just as the person who's responsible to perform can seek a discharge, the other party is equally eligible to seek a discharge of his payment commitments. Please keep that in mind. So if you trigger a force majeure in one situation that I cannot perform because of COVID, I could not step out of Delhi because the other city where I was supposed to perform, the flights were not there. There was there was no means and mode of movement into that territory. Even if I did, there was a lockdown in that city, and therefore I could not perform because it was an act of God or a force majeure. Similarly, even if you were to go there, you went to the premises, somehow you scrambled and you made yourself physically available. You had a bulletproof car or whatever thing, you had a VIP luxury jet, you managed to reach that spot. The organizer will say, well, how could I pay you, because there was no audience, because the audience could not come because it was COVID, and therefore I cannot pay you. So therefore it cuts both ways. It's a double-edged sword. So just as a person seeks a discharge of his contract or obligations citing force majeure or act of God, the other party can equally stand up and say it is an act of God, therefore I will not pay you for that. Okay. Now, it's a complicated situation. What we have been noticing, And here I'm going to go beyond art world and into the the hardcore commercial world, the brick and mortar commercial world. The government of India, as far back sometime in February, end of March, had issued a circular saying that China COVID was a pandemic and therefore a force majeure event. The government of India did that to protect the industry and not to renege contracts. Please bear in mind. The purpose of government of India declaring China COVID as a pandemic or as a force majeure was to protect the industry. Why? Because the industry comprised of various players. We had a commitment to deliver services or goods to the various government bodies as buyers. And if you do not deliver, let's say your delivery was scheduled to be March 30th 2020, and because of China COVID you could not source your raw material, or you could not gather your man machinery, etc., etc., you were breaching the 30th March deadline, then you would be penalized for what I said, compensation of damages, liquidated damages or whatever, to ensure that people who are service deliverers, supply deliveries of goods or services, they don't get penalized. The government introduced that this is an act of God, and therefore any such delay that happens beyond 30th March on account of China COVID, no such compensation or damages will get triggered by the counterparty, whether it's an NHI, whether it's an NTPC, whether it's a, you name it. But what we also noticed, that the government tried to say that even if you may have delivered, I will not pay you. Okay. Now that kind of situation has been far and few. Okay. It's in very exceptional situations that the government have done that. Even where they have done that, the government has thereafter come out with circulars saying that, well, the payment should not be stopped. If the services have been performed, then the payment should not be stopped. And the government cannot stand up today and tell the country and citizens that I don't have money. That's farcical. They have the deepest coffers that is available. If you have received the services, technically speaking, you can stand up and say that please don't, I don't ask me for payment. But then that will be very unfair, because your ability to pay is not dependent upon COVID, because you had organized the money irrespective. You have purchased the services, and therefore to say that I will not pay because of China COVID sounds quite strange and probably not the right thing. More so, what we have also noticed is that where the services may have actually happened prior to the China COVID declaration as force majeure, because let's face it, very rarely have services happened during this COVID period, okay, during the lockdown period. Most of the cases, all the performance, dance, drama, etc., theater, and fun and frolic and various other spiritual things would have happened pre-COVID. And if those services were rendered pre-COVID, the government cannot stand up today and say that because of China COVID, I don't have money to pay. Courts will throw them off very clearly, because your commitment to pay accrued in respect of services that were rendered prior to lockdown or prior to force majeure. And therefore, you cannot take the shelter of COVID or shelter of force majeure to say that I will not pay. In fact, there was a case that came up before the Delhi High Court, and that I'm giving it contextually because, and we can relate it back to your industry also. The fellow had defaulted in performing his scope of work, and the delay happened in sometime in January. There was a 500 odd crore of bank guarantee that he had tendered to the counterparty, saying that if I do not perform on time, the counterparty can encash the bank guarantee. And the counterparty went about encashing the bank guarantee. That fellow came to the court saying that no, because of China COVID, it's a force majeure, etc., etc. Please refrain them from from encashing the bank guarantee. And the court said, sorry, the problem was pre-COVID problem. You defaulted at that point in time, and if that be the case, they are obliged to encash, which means find out at what point in time the performance was due. If the performance was due prior to COVID, the government cannot take shelter of this COVID to not pay you. That's the simplistic way. I'll quickly come back. These are all details which you need not. So basically the solutions of all of these things, you can, if you have a force majeure clause, you can seek for a termination or a discharge of the contract. You need not even perform, but then you need to have a clause for that. You can look for a temporary suspension. You can say, okay, the event is deferred, instead of June, July, August, etc., let us do it in January, February, March. You can defer the point in time when you need to perform without any extra cost. Or you can say, if let's part performance is good enough, and the contract is discharged. So there are many ways you can do it. Okay. So in short, this is your slide that you need to focus on. Take a close look at your respective contracts. Get it reviewed if need be by specialists, and there are contract lawyers and IP lawyers. A combination of that both is very important. Firm up the view on your contract post diligence. What are the misgivings and what are the defects? Then plan a remedial step. You want to short close a contract and create a fresh one, you're welcome to do that. Or you want to carry on in life because that's a concession you make, that's fine. But at least you know where the fault line lies, so that you can take remedial actions. And all new contracts, you must follow all the best practices that I've spoken about. Whenever in doubt, seek help. It is no good to do self medication, even in the context of law as much in the context of medicine. Follow the best practices. And the last two lines are very, very critical. Monetization, like I started by saying that, and I'm ending with this, monetization of skills does require one to go through some degree of legal pain, and that's a given. That's a given. Okay. And if you tell me that this, we have this guru shishya parampara, and therefore how do I even raise those issues? Well, the fact is, it is your protection that is as important. Of course you will respect the guru shishya thing, but there's only so much. At some stage you need to protect your interest as well, your skill set as well. You can't be exploited beyond a point. It is up to you. You may choose not to, you may choose to yield, that's fine. But if you choose to yield, then don't turn back and complain. Then you are complicit in the whole thing. Anyway, so that's the few conversation, that a few points that I wanted to speak with you all. Happy to take questions after we hear the learned discussion.
Thank you so much, Sujit, for this very wonderful presentation. You've actually opened our eyes to many aspects. We did have the sort of niggling feeling about the fact that the government had let us down, but maybe there is a point in what you're saying, and to raise that issue and some other issues, I'm going to invite without any further delay Sanjoy Roy, so that we can stay within the time schedule. So Sanjoy, may I ask you to say your points in response to what Sujit has said, and additional points from your experience and understanding of.
Thank you. Thank you so much, Arshia, and thank you, Sujit. I think what you've touched upon today is absolutely vital. And for everybody who's on this panel, yes, it sounds complex. It is complicated. As you know, you may want a contract, the other party may not want to. You have no idea where to go to frame a contract. And these are some of the things that perhaps towards the end of the session we can talk about. In my earlier role as president of EMA, one of the things that I did for EMA was created standardized contracts for artists, for organizations, for individuals, and they could access that as a template. Very important, because as Sujit said, until unless you enumerate what you need and why you're doing something and who you're doing it for, invariably the artist gets taken for a ride. Between you and me, I don't see that changing anytime soon because of the nature of the beast. And that's what I'd really like to address for a second. How does power flow? We know that at the end of the day, while everybody pays lip service to the arts, you all are aware that even yesterday or day before yesterday, in these very difficult times of COVID, we suddenly have a government who, instead of supporting the arts, has asked 27 artists to vacate their homes, knowing fully well that there is very little sustenance that these artists have access to. The problem stems from here, that we as an artist community don't have a collective voice. We within the artistic community, whether it's music or dance or literature or film or platforms or what it is, we tend to cannibalize each other, and we are too busy being in dissonance with each other rather than coming together and fighting for what is our right. And when I say what is our right, I again come back to what Sujit began by saying. Your contribution, I mean, for example, when a potter creates a simple or a humble diya, when a weaver creates a piece of a woven material on the loom, or in any of you when Rama Vaidyanath creates a piece of dance, remember it's not just that moment of creation that is being priced. It is generations of knowledge and learning that comes into creating that piece of art, and even the humble diya. Can you and me throw up some clay on a potter's wheel and create a diya? No, we can't. Can you and me suddenly decide after 6 classes that we can dance a Bharatnatyam performance? No, we can't. It's not instant Maggi noodle. Unfortunately, what people don't realize is that age old derivative of knowledge that goes from generation to generation. And as Sujit said, that Guru Shishya Parampara, for a second, and I want to stay with that, that needs to be priced. That is your right. Again, because the power flows from sponsors and governments and people who we continue to have to owe the artist's existence to. You're always in a position where invariably, when somebody says, but हम तो आपको प्लेटफॉर्म दे रहे हैं, आप हमें इतना चार्ज करेंगे, बस 20 लोगों का है और उसमें ऐसे लोग आएंगे जहां पे और भी लोग आपको इनवाइट करेंगे. And invariably, this exhortation from the client or the sponsor or the organization or the institution invariably wins. Why? Because we're not organized. Because we don't have an organization that we can go to and say, hey, this is the problem. This is the person who has cheated me. As Sujit rightly said, at the end of the day, sure, you may say an email is a problem, you need a stamp paper, etc. We don't have access to any of that. But at the end of the day, when you go to court, justice doesn't necessarily flow in the way that you and I would like justice to flow. Do we have the resources to be able to go to court? Today at Teamwork, there is nothing that I do which is not legally vetted by our in-house lawyers, which is the reason over the years we have won so many cases, whether it's against Sony in 1995, which was the first big copyright case that we won. And Sujit, we won it on the basis of emails that we had and typed letters. We had everything. Sony copied what we had given them, created a show. We had withheld what we thought was the key moment that would have made the show successful, and their show wasn't successful, and we sued them and we won. Similarly, when we did Sounds of Freedom in Delhi 7 or 6 or whatever years ago, we didn't realize that a particular police person in that in Delhi police had a kundak with us, because apparently we'd gone over his head in a previous occasion and appealed to somebody senior to him and ensured that Bonjour India happened, the big circus event that we did at the Jawaharlal Nehru Stadium. But when we did Sounds of Freedom, where we had Bob Geldof and everybody had arrived in town, we had already spent about 3 crores in making that possible and raising a voice musically. On the eve, meaning this was on Sunday, on Friday, the DCP South withdrew the license for the concert. We appealed to the Lieutenant Governor. He sent us to the police commissioner. The police commissioner called in, and remember, we were able to do that because we were connected. All of us on this chat are connected. We know somebody, we know Arshia, and therefore we're connected because she is the connector in this world. But that's how it works. What about people who don't? And in the commissioner's office, this is 7:30 p.m. Friday night, commissioner said, I totally agree with your point of view, Sanjoy. We must see how we can support you. Can you step out? Because this other gentleman who kept objecting, and I still didn't realize that he was the gentleman who felt, hurt or whatever, or belittled. So we stepped out. 20 minutes later, when we were invited back in, the commissioner said, I would have loved to help. Unfortunately, I can't because he's not relenting. And with a smirk, the other guy said to me, Sanjay ji, aap to itne powerful ho आप कोर्ट क्यों नहीं चले जाते हो? I came out furious because, we had all of these artists from across the world, etc. And in my head, I was, let's go to court. There was no lawyer available. We finally got through to Abhishek Singhvi, and I said, Abhishek, this is the case. The concert is on Sunday, got 450 artists together. They've collaborated. It's Sounds of Freedom. How can we not stage it? You have to take this court. He said, Sanjoy, you don't have a hope in hell in getting a special hearing. I said, don't worry, I'll get you a time. Call the registrar. Can you hear me?
Yes, yes.
Can you hear me, guys? We
Yes,
called the
Sanjay.
registrar, got a time. Can you hear me? We called the registrar, got a time from the then acting Chief Justice of the High Court in Delhi. Told Abhishek she's given us time at 10:30 in the morning in her residence. Abhishek turned to me and said, there is no way that you're going to win this case. She's the most conservative judge ever. She will see you in her courtroom and she'll dismiss the case. I won't give you the name of the person. I said, Abhishek, I'll stay out. You go and argue the case. He said, yes, but I need you. You come in after half an hour. Anyway, we went in after half an hour. The case was being heard, and I instinctively knew that we would win because the kind of excuses the Delhi police was giving her. So she said, why are you objecting to this? They said, Madam Ji, it is Sunday. She said, absolutely, Sunday is the best day. But Madam Ji, they have taken NSCI, a lawns which is near a metro station, there'll be congestion. She said, anywhere in the world, this is the best way to do it. Their last argument was, but Madam Ji, there'll be girls and boys in the concert together. Anyway, she ruled in our favor. It is a landmark judgment. She ruled in our favor. We left the court celebrating, etc. Delhi police challenged the ruling. She recalled the court in an hour. Her mother broke her leg. She said, I will wait to hear this case before I take her to hospital. She again ruled in our favor. We went out. Abhishek said, this is incredible, unbelievable. As we were leaving, the court was called back in session. The registrar came out and said, calling the court back. We went back in and she turned to Abhishek and said, please tell your client that you all may be celebrating that you won this judgment, but there is nothing that you can do to receive this judgment on a Sunday and give it to the police. She said, will refuse to receive it and you will still not be able to do the concert. Of course, other than that, the police had done a lathi charge, blah, blah, blah. That's a different thing. So what did she do? She appointed the registrar of the High Court as a special commissioner of police for that day and got him to receive the judgment from her as the police commissioner. And he was then enjoined to be at the venue till 10:30 at night, for which he had given permission. It was incredible landmark judgment. Of course, we still lost the money. Nobody could come in, blah, blah, blah. That's different. The courts of laws can, if they're appropriately challenged, create these landmark judgments, which are vital for each and every one of us. But again, because so many of us have no access, we don't know how to, we cannot afford lawyers, we can hardly afford a meal today given COVID. Therefore, again, we need a collective voice. And as Sujit said, where the courts can't intervene, what we should look at doing is ombudsman. Going to an ombudsman. The Nani Palkiwala Center for Arbitration, both Mr. Dattar and Payal Chawla, they are available and they will be available to all artists to make good their offices in Connaught Place, in Chennai, and in Mumbai, should anybody ever wish to use them. But to do that, as Sujit would say, you need a clause in your contract which says that you're open to arbitration, and you must also ensure that the court which will adjudicate must be in the place that you are in, so that you're not being dragged up and down. As many of you know, the last 20 years of certainly our work within the creative industries, not just in India, but across the world, has been ridden by court cases, people filing cases of sedition against me, blah, blah. I've got numerous non-bailable warrants and blah. But the only way that we are able to survive is because we have recourse to legal remedy. Only way. This is not just true of India. In the UK, when we were doing the Great Arc, and we think that everybody outside does work differently. No, they don't. If they can take advantage, they will. In this particular case, we had contracted a company to create the infrastructure of the Great Arc exhibition, which meant the grid had to be created, the equipment had to go in, which is the great equipment of Lord Everest, etc., which had measured, what we know as the Himalayan range, and then the rest of the circus tent, because it was a 10,000 square meter exhibition, unheard of in Oxford. The person who was supposed to produce this, was supposed to send us the infrastructure, was based in Germany. Contracting firm was a Birmingham firm. They reneged on their contract. Every hour that we had people standing, it cost us £3,000. We finally went to court. They finally brought it all back together after 3 days of us having to pay this kind of money. We lost 150,000 pounds. But one of the things that I'll add, the only reason why we survived is an additional thing: insurance. All of us forget how important insurance is. And Sujit, any other presentation that you do to the artistic community, I would entreat you to ensure that insurance becomes part of that. Whether you all are doing your own festivals, insure it. Yes, it's expensive. Insure it. Whether you're going on a tour, insure yourselves. Whether you're taking artists and other dancers and performers and musicians, insure them. If you're taking the mridangam and the tabla and the sitar and so on and so forth, insure that. So that even if they don't reach, even if something happens in a foreign country, and if you're abandoned, which invariably you all are, you are insured and will be safe. Yes, it costs money. Build it into your discussions with whoever the source person is, who you are going to be performing for. But do not take uh, take heed, take strength, use no as a tool of power. Yes, we live in a very insecure world in the arts. Yes, we don't know when our next meal is coming from, and therefore we say yes to everybody. But every once in a while, go with your instinct. If you feel instinctively that this is not something that's going to work for you, take recourse, walk away from it, walk away from it. As Sujit said, make sure that you're legally covered. I hope that one of the things that we will achieve today or as part of Arsha's series is that we will work, and this is a dream, that we will work collectively together, as I keep saying, and I use FICCI's hat to do that, to be able to bring these issues of policy to government and to the industry, etc., to see how best we can address this, and come together as one voice. Even today, we are divided. With this dispensation against, forget all of that. Can we come together? Can we speak in one voice? Can we stand together as a collective? Can we speak the truth, which is what, or can we speak the many truths, which must coexist, which is how we know culture to be? And can we collectively bring about a change? Not necessarily for us, because our time is over, but for the generations to follow. For those people who continue to want to learn the Carnatic violin tradition of Bharatnatyam, Kathak, incredible in this world. No other culture has this kind of living tradition that we have. Government will not be our savior. We must be our own saviors for this. All 1.3 billion of us. Arsha, over to you. I know we're running late in time. I can carry on forever, but my Bhashan Baji, you can hear it anytime.
But Sanjoy, this is so fascinating. Just as it was wonderful the way Sujit unpacked the issue of contracts and force majeure and backdoor entries of clauses and things, conditions. I think listening to you speak was like watching a movie. I was almost biting my nails, the thrill and the excitement and the lawyer and Abhishek Manu Singhvi and the Delhi police, which, by the way, is constantly. I have my own set of stories about Delhi police. How to handle them is another thing. But yes, it is very true. We need to speak in one voice. We need to work together. In fact, I have just last night written a little note on what is next with this series. And the note begins with, I feel like an Ima. And Ima is that Meitei word for the society mothers, It's not, our time is over for sure. But what about all these so excited people, young people, I see myself like 30, 40 years ago when I see them, and how can we help? So people like Sujit open our eyes, but then you mentioned that there are these preconceived contract templates. There is the Pak what is it?
Palkiwala,
Uh,
Nani
Palkiwala
Palkiwala
Center.
Center.
Yes. And you raised the issue of ombudsman. My secret agenda for this program was to get to this situation of the ombudsman. So for that, policy initiatives have to be made. Vicky could well take the lead, because really no artists, that artists are too creative, too mood oriented, too mood creating also. So to read the fine prints and all that is a little hard. But to be able to get to an ombudsman who could help us resolve disputes and get more bang for the buck for the artists, there are two partners: the artist himself or
Archie, can
herself.
I just intervene there for a second? And you're totally right. Artists are completely imbued with the act of creation. Unfortunately, in India, that same artist has to be the creator, the thinker, the administrator, the teacher, the lawyer, the cook, the tea maker, the cleaner, the sweeper, so on and so forth. But until and unless the artistic sector itself professionalizes, and we have to get to what Sujit said. We have to be aware of our rights. We have to get managers. We have to get art administrators. Arshia, you know the absolute value of being an arts administrator. It is, I mean, there is no other way. And artists too must address that and understand that without that input, they will continue to struggle. They will continue to go from risk to risk, from financial loss to financial loss, until unless you're able to professionalize across the board.
I have a suggestion to make, and I could be out of place here because I don't work in that industry as much. But there is this concept that we have seen across many years, that for a given sector, given unorganized sector or disorganized sector, or a sector
Which
that
the
is
arts
prone
are.
to, yeah, with the sector which is prone to abuse, misuse, subjugation, various things, the government plays the role of a regulator. The job of the regulator is to ensure fair play. So you have a regulator for the electricity, the world. You have a regulator for the telecom world. You have the regulator for the television network. There's a regulator that is being spoken about. There are all kinds of regulators the government bring in to make sure that there is a fair play. One way to look at is to probably approach the government to say, can you think of a regulatory mechanism which kind of controls in some manner or provide some
But
Government
kind of.
and government and the
control
arts,
is
बाप रे
bad.
बाप, regulation खत्म. वो तो
No,
हम
no,
सबको नाश करके रखेगा.
no, no, I understand.
वो
I
तो
understand.
एक ही.
I understand. I understand.
Government should
The
have nothing to do with the arts. The
fair point.
only reason why the IT, this thing grew in the way that it did, and when the fashion world grew, fashion beauty contests, was because no ministry for fashion beauty contests and no ministry for IT at that point of time.
Fair point. Fair
Government
point.
and
So
the
it's
arts,
it's again, it's a
but
double-edged sword.
self-regulatory,
Yeah,
self-regulatory, absolutely.
the, that is like I said, if for those people who don't have access to all the comforts of a proper environment, the regulator can play a role. And I'm completely alive to the fact that as soon as you open it to the regulators, it becomes a foundation for further disputes. but some kind of a meeting of mind or some kind of quasi body can be lobbied with the government to come out with some kind of a mechanism. Else, the only option is, self help, which is like be educated, write your contracts, enforce your rights.
Yes, actually, that's right. And as I'm reading the chat messages, this is a very unique webinar. The chat messages are helping each other, and they have such a sense of humor. Uh, Swagata Pillai talked about how you need to be like Durga Das Bhuja to be able to deal with all that demands on the artists. And somebody says, she says, the regulatory framework is a laugh. The government has responsibly made it clear that creativity and culture are irrelevant to social and commercial and political pursuits. Now, this is that residue of the hurt that COVID threw out. We have to find a way around it. I know, Sanjoy, I see your thumb going like that. But you can always hope. The point that you made about the dehousing of the artists, 27 artists, is being relooked at. And I really don't care what color clothes people wear who make the most powerful argument and get the things done. There's just one question that I know that you both have answered many questions on the chat. But there's something that came from my trustee, and so I must ask you. She gets a little preference here, and that's Rama Vaidyanathan. Is the artist obliged to pay back her advance to the organizer in case the performance is cancelled by the organizer?
It
It
depends on
it
your
really
contract.
depends on your contract. Oh, I think both of us said the same thing.
So it depends on the contract, which brings us squarely to the point that contract writing, putting things down on paper in simple language, imagining all kinds of situations. So I would like to share towards the end a little experience I have with contracts. When I started working on the India Habitat Center, it was a new project. So we wrote initially just a letter. We will do this, you will do that. And then slowly that letter grew. It grew to define how many cups of tea and coffee we are going to serve at how many, in how many times, when will you have the light rehearsal, well, when will you have, but so it kept growing. Now I think it is sort of settled, but the habitat has been in operation for over 20 years, so it takes a while for things to settle. Now, why do we need to reinvent the wheel? Sanjoy, may I ask you to please share with us this template of a contract, each one, if we could sort of use it. And if you could send me a copy, I will send it to all those who registered, because there are many people who are on other, like I said, Facebook and YouTubes and all that. Everybody I will send a copy to. And from you, Sujit, I request the permission to be able to share your PowerPoint with everybody so that people can go back to these questions. And okay, so now things have started moving faster. The fate of the Lit Fest. Okay, political will. So that's fine. This discussion is going. So may I share your PowerPoint, and may I
Sure.
share your template, and each one can build on it. You have already mentioned best practices in it, so we can just make sure that the contract reflects everything that you have said and anything more. Now, the IP lawyer, intellectual property rights lawyer, we had featured in the previous section, which was on copyrights and copyrights and plagiarism. I don't think we did enough justice to plagiarism, but copyright certainly we did. And I have a lot of young lawyers from your alma mater, Sujit, NLS in
That's right.
Bangalore, who are
That's right.
helping me prepare little one pagers saying copyright made easy, so contract made easy, that sort of a thing. And I just keep sending it over the, because mostly the talks are about 2 weeks to 3 weeks apart. So I just keep sending so that everybody builds up the thing. In case anybody wants to know, and particularly the two of you have the right to know, what it lies ahead with this material that we have got, thanks to your intellectual inputs, is that we would like to bring out a book, and so I'd ask also permission that On the basis of our conversation, we will transcribe it. We will get both of you to approve of what what we have ascribed to you on the basis of the transcription. And if you think it's okay, we would like to bring it out as a chapter in a book. Sanjoy, does that
Oh,
at all work for you?
absolutely depends on the contract. Contract for Arshia, handing over our rights for this recording to her. But
Go
I
back
just
and
want to sort of focus on one. I just wanted to focus again on one aspect in this, is that again I come back to the issue of that the need for a collective voice. And I know it's difficult, but I would really urge all of the gurus and the masters who are on this call to think this through. For too long has this sector been at the receiving end. Please remember, in the government of India, there are 8 different ministries that look to the creative sector. 8, not 1, not 2, not 3, 8 different ministries. They don't have a sense of what we need, let alone where we can go. The future of India's economy will be the creative economy. That is the future. So until unless everybody gets their act together, including us, we're not going to be able to get there. So we have a responsibility and a duty, and we must come together again, Arshia, on this. And I would again urge you, under this aegis or any other aegis, to create these platforms where we debate, discuss, and we create an equivalent of a FICCI or a CII or an EMA or whatever for the creative and the arts sector. Very important.
Yeah, count on me. I feel like an
Thank you.
Ema nowadays.
I'm going to have to bounce, unfortunately, because my time is now over. But
Yes,
thank you
I
for
know
the
that.
session,
Thank you, Sanjoy.
Archana.
Thank you, Sujit.
Thank you.
Wonderful. I'll
Thank you.
send you the chat exchanges as well.
Thank
Thanks.
you.
Bye-bye.
Thank you. Good night,
Thank
all.
you,
Bye-bye.
friends, for joining in. Our next session is on the 15th of December. I want you to join. I'll write to each one of you. It's almost a philosophical session. Okay? Thanks.
Thank you.
Ma'am, I have a one contribution.
Anji,
Yeah, I'm
sorry.
Anil. My name is Anil Nimesh.
Yes, Anil, how are you?
I'm fine, ma'am. Actually, it's a wonderful session I have, had. So I have learned so many things. By profession, I'm an architect. So I'm
Creative enough?
yeah. So I'm listening to the issues, whatever is addressed by in a different fashion. So I have a one strong, suggestion over here. Like in our profession, like as an architect, what we have from the center government is we have a statute which is basically address, which basically recognize, which basically introduce our self as a professional to the society. Okay. So what I found over here, like yeah, it is discussed the contract about it, but the important point which is required in law is to have a statute. It means an act has to be passed in favor of artists, all the artists, maybe like Indian Artist Act, something like that. So if you have something like this, if you all together bring out in Parliament an act which as a bill and which can pass as an act, so that will be help you a lot, because it will basically address the all the artists or recognize all the artists in state government and central government both. So this is my advice. If you can get this statute, so so many things can be formulate and even regulate, and it will be supporting you from all law point of view. So this is my
Thank you so much, Anil. I think what you have said is a very, very important point. And COVID, again, I'm sorry to keep referring to COVID, but really there's going to be life before and life after COVID. But the COVID period also made us realize that the government does not even have a list of artists. There is no way that we can identify who is an artist, who is not, how to contact them, none of this. And it struck me that there is the Council of Architecture, for instance. Every time you graduate, you become a member of the Council of Architecture. So there is some record, some point where this record is, but we have no such record for artists. So we do not even have an existence. Yet it's important to recognize that from the beginning of nation building, since the beginning of independence, you know that arts has played such a key role in the freedom struggle. But from 1947, and when the planned economy begins in 1950, when the planning commission is set up, guess what? From the very first 5-year plan, the arts are part of the development paradigm. And still we stand here disorganized. So this is not the program, because we pretty much ended it here, to take this into depth, but we will certainly apply our minds to it and begin discourse to raise the issues that Sanjoy Roy has done. We don't want government to control us and regulate us in that manner. Self-regulation is very important, but we must become one voice. We must become a power center, a lobby group. We must count. Right now, we are not counting. That is why they can get away with reneging on contracts of performances done before COVID also. Oh, and that is why they can get away with COVID or no COVID. 27 artists have to leave. All of these are things that we must start thinking. पहले अपने आप अहम को पहचाने, और कॉन्ट्रैक्ट जो होता है ना, वो अहम को पहचानता है. Who am I? What am I worth? Am I worth preserving and protecting, or am I a people's pleaser? So many issues in this conversation. Thank you so much. I will be applying my mind to it. You know, we have an email, a special email called artsandthe.law@gmail.com. Arts and the law, spell it out. If you write to me, I will be in contact with you. Thank you so much for joining in. Thank you, India Habitat Center Visual Arts Gallery. And I see you all next on the 15th of December. Bye.